It's always well worth reviewing and remembering what our rights are here in Canada when it comes to dealing with police and why this channel is called Don't Talk TV. So, when a viewer recently emailed me asking whether he needs to identify himself if he's just walking down the street minding his own business and police come up and want to speak to him, I thought that was a topic worth doing. We've dealt with it in some prior episodes, but it's worth looking at it again in more detail. Hello, my name is Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So as I said in the preamble, a viewer recently emailed me asking, do I need to identify myself if I'm just walking down the street? The short answer is no. As long as you're not doing a licensed activity, that being an activity that you require a license for, you do not have to provide identification. So when we speak of licensed activities, that would include things like hunting, fishing, driving a motor vehicle, just for three examples. For anything that you're required to carry a license in order to do, the police do have the right to stop you and ask you to produce that license to prove that you have the right and the qualification or the license to do that activity. But if you're not doing a licensed activity, you have absolutely no obligation whatsoever to speak to police if you don't want to. Now, we've talked about this in a number of different episodes, and I do highly recommend that viewers have a look at episode 1 of Don't Talk TV. Now, that dealt with one's right to not answer the door, but the same reasons that you don't have to answer the door of your house are the same reasons why you don't need to speak to police if they come and speak to you while you're minding your own business, not doing a licensed activity. Of course, even if you're doing a licensed activity, all you have to do is provide them your license. You don't have to speak to them further if you don't want to. Episodes 85 and 87, I also touched on this topic, so you can look at those for some refresher and some more information above and beyond what we talk about here in this episode. But just to flesh out a bit more what I said about you having no obligation to speak to the police, that's because you have the right under the Charter of Rights and Freedoms to life, liberty, and security of the person under Section 7. You also have the right under Section 8 to be secure from any unreasonable or arbitrary search. Asking for your identification is a search, and stopping you so that you can be asked for identification, that is a detention, although it may be a brief one. Now, for any detention or search by police, it has to be authorized by law. Now, that can either be statute law or common law. But there's nothing in any statute or in common law that gives the police the power to just randomly stop people to ask for their identification. That is an unlawful search. We'll take a quick look at the case of Her Majesty the Queen and A.K., who was a young person. This is a case out of Toronto from 2014, the infamous carding case that people may remember. But it gives a nice overview of the law I'm talking about. Skipping down to page 13 of the decision in paragraph 54, the court lays out a summary of this law. Now, this is in the context of police having stopped a number of individuals in downtown Toronto. As I understand it, they had actually been in a vehicle, so the police would have been able to ask the driver for his identification. But let's have a look at this, and this will explain why you don't need to speak to police if you don't want to, because their stopping you would most likely be in breach of your rights. So, paragraph 54, the judge says, the respondent, Crown, must establish that the officer was acting within the scope of his common law powers when he detained Mr. K, that being the young person in this case. So in the judge's view, the proactive policing aspect of the night's events, going down a lane to see why citizens might be there, was legitimate. But once the police knew the group was going to their parked car, to now prolong the investigation because of the price of the vehicle, the age and color of the occupants, takes this fact situation out of legitimate. The Supreme Court decision of Mann makes it clear that a brief detention for investigative purposes is a recognized but limited police power, but there needs to be reasonable grounds to suspect in all the circumstances that the individual is connected to a particular crime, and that such a detention is necessary. So note, there has to be a particular crime that police are investigating, and they need to have a reasonable suspicion that the person they're stopping is involved and that the detention is necessary to investigate this crime. So you can see right here, just stopping a random person on the street, if the police aren't investigating a particular crime, they're not going to have the right to do that. So the officers in this AK case, they cited graffiti and theft of construction materials as the particular crime. Yet there existed no evidence that would give them the requisite reasonable grounds to believe that AK and his friends were involved in any of that stuff. The court then quotes the Ontario Court of Appeal in Simpson that specifically warned against officers allowing to act on hunches. It said a hunch is based entirely on intuition gained by experience cannot suffice, no matter how accurate that hunch might prove to be. Such subjectively based assessments can too easily mask discriminatory conduct based on such relevant factors as the detainee's sex, color, age, ethnic origin, or sexual orientation. So again, the officer can't just stop you because he has a hunch that something might be going on. There has to be something legitimate. So I think that case makes it quite clear that random stops, I mean, it's a case that got a lot of news coverage because the police were doing carding, which is where they just stop people randomly, collect their ID, and then keep a note of where they saw these people, and they kept a database on anyone they stopped. The court said that's a no-go, and you can see why from what was outlined there. So having reviewed this, I hope that you'd have the confidence that if you're stopped by police on the street, you know that you don't have to identify yourself to them if you don't want to. Now, I mean, you can speak to them if you want to. That's completely your choice. But the point of this video is, what is your right? What do you have to do or not have to do? And just as you do not have to answer your door, which is a persistent myth that people still think that they need to answer the door, please watch episode 1 if you're in any doubt about that. You clearly, under Canadian law, do not have to answer the door to your house. Likewise, you don't need to speak to police if you don't want to. And you don't have to identify yourself unless you are doing a licensed activity, or if the police do have reasonable grounds to believe you're involved in something. But if they believe that, they have to notify you of that. And because Section 10A of the Charter of Rights and Freedoms guarantees that you be informed if you're being investigated, and then that may trigger a right to counsel as well. And then, of course, you have right to silence, because now you're a suspect. So this video is not legal advice. If you need legal advice, contact a lawyer so they can give you specific advice tailored to your particular situation. If you want me to be that lawyer, contact information is below. If you have questions or topics you'd like to see us discuss, please send an email to the email address listed below. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media.